Defendant, as part of the plea agreement, waives his right to appeal. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement.
Did I just lie out loud for the whole world to hear?
This is not a Rule 11 agreement.
Lord say you got some splaining to do.
And see through you, see your true colors.
Like you, be strong to hold the powers of the sun.
I show you how deep the rabbit hole goes.
Listen to Pavarotti. Can I be your superhero?
Hello, welcome to The Revealing. I am your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And you know, over time, because of the investigation that I've done into this case, I've exposed a lot of things, a lot of lies. And for a while, it was very difficult to dive in, do all the research necessary to even be able to expose some of those lies. But at some point, this thing became so easy to expose lies, it's almost not even fun anymore. And in this video, I will expose yet another lie, huge lie, made by Judge Hippler, right? This is just my opinions. Well, I mean, kind of, but I mean, it's irrefutable. So made by Judge Hippler. I mean, we're gonna bust in on this lie. And you know what's bad is because of the reporting that I've done around this case and the research that I've done, I'm probably the only person that would even notice this lie and have the ability to expose it, because I don't know. I don't know why that is. But for those of you that have followed me for a long time, you know that I have dove in on specific things in this case and events surrounding this case that I thought were odd. For example, when I began to look at all the criminals that I thought potentially had some culpability in this crime and charges that they were facing at the time, and circumstances around those charges seemed to not line up with reality. And there was something that was uniform in all the people that I looked at. And that was the fact that they got sweetheart deals with the court system. And in all of those sweetheart deals, there was something in common. This thing called a Rule 11 plea agreement. For those of you that have followed me, you know that I have invested significant amount of time in researching and explaining the Rule 11 plea agreement in Idaho. And for those of you that haven't followed me for a long time, let me refresh you on some of the information that we discovered. And we went into local law firms there in Idaho to do some of this research about these Rule 11 plea agreements, and here's what we found. And sometimes to find the real information, it's best to go to the source of the people who is applying the real information. So local defense attorneys there in Idaho would have the down low on what a Rule 11 plea agreement is and how it's applied and not applied in Idaho. And a Rule 11 plea agreement, according to them, is a binding plea agreement. It's an agreement entered into by the parties for a certain sentence if the defendant pleads guilty to a specific criminal charge. A plea agreement under this rule binds the court to the terms of the agreement. In other words, the judge cannot add, subtract, or alter the terms of a Rule 11 agreement. This differs from a binding agreement where the parties would each argue for the sentence they feel is appropriate, and the judge would make the final determination. However, the court may be bound by the terms of a Rule 11 agreement, but is not bound to accept the agreement. Now, there are pros and cons to Rule 11 agreements. The most obvious benefit is having the ability to negotiate your sentence without the risk that a judge will sentence you to something more severe after you have already admitted to the crime. Now, for the most part, determining who is eligible for a Rule 11 agreement and who is not will depend upon the judge and the severity of the charges. More often than not, Rule 11 agreements are found in misdemeanor cases, not felony cases. Occasionally, a Rule 11 agreement will be accepted in a felony matter, but most district court judges, those who handle felony matters, will not accept Rule 11 cases, except in the rarest of instances, if at all. Some judges will not accept a Rule 11 agreement under any circumstances, and some prosecutors will not enter into a Rule 11 agreement. In fact, certain jurisdictions around Idaho have an unwritten standing rule that Rule 11 agreements are not to be accepted, even in misdemeanor cases. So if this is what all the attorneys in Idaho believe about this Rule 11 agreement and its unwritten rules, I would have to say that's probably the norm. Therefore, when I looked at things in this case around Rule 11s, Bill Thompson and these people that I'm talking about, it didn't really make sense, according to local attorneys there in Idaho. And y'all may remember that people surrounding this crime and potentially involved in aspects of it and in aspects of the investigation, in my humble opinion, began receiving these Rule 11 plea agreements on a consistent basis by prosecutor Bill Thompson there in Idaho, all accepted by John Judge, which I thought was very odd. People like Farley, who received what I've referred to as the deal of the century, Rule 11 plea agreement. Tanya Rhodes, who was arrested with Farley, who's connected to a lot of people in this case, Rule 11 plea agreement. How about Michael Burrows, who is the direct connection to the Aryan Knights, Rule 11 plea agreement. And then there's James Curtis Leonard, who for no reason whatsoever received a Rule 11 plea agreement in his case. The agreement came through for Brian Kohberger. My first inclination was, is this going to be another Rule 11 plea agreement? And to my shock, when I heard the judge say this in court, I went, wow, this one's going to be a little different, I guess.
This is not a Rule 11 agreement.
Imagine my shock as I'm reading the new filings from prosecutor Bill Thompson in the Brian Kohberger saga of trying to get additional restitution money for the victims' families. And let me read it to you as well and see if we notice something that's quite odd and proves more lies in the case. So first of all, I went back to the July 2nd plea agreement that was written in the court record and checked it to see if it stated what type of agreement this actually was. And it does say that the Latah County Prosecuting Attorney's Office, the defendant Brian Kohberger, and the defendant's attorney Ann Taylor stipulate to the following plea agreement. And it says plea agreement. It says the defendant will enter guilty pleas to the following counts of burglary, unaliving in the first degree, unaliving in the second, unaliving in the third count, and unaliving in the fourth count, and unaliving in the fifth count, I guess. Let's see, count 1, unaliving in the first degree, count 2, unaliving in the first degree, count 3, unaliving in the first degree, count 4, unaliving in the first degree, and a felony in count 5 as stated in the indictment. Okay, so count 5, I guess, is burglary. All right, defendant will be sentenced to 10 years for count 1, fixed consecutive life sentences for counts 2 through 5. State may seek restitution orders regarding funeral expenses and crime victims' compensation reimbursement in the amount to be determined. So crime victims compensation reimbursement from the crime victims compensation fund. So we're looking to get the families more money actually refunded to them. And defendant understands the nature of the charge, to which defendant agrees to plead guilty, acknowledges that he is not being coerced into entering this plea of guilty. Consequences of pleading guilty, including maximum penalties that may be imposed and any mandatory minimum penalties. And that by pleading guilty, he waives his right to a jury trial, to confront his accusers, to refrain from incriminating himself. By pleading guilty, he waives his rights to a jury trial, to confront accusers, and to refrain from incriminating himself. Defendant further acknowledges he's satisfied with his legal representation, has reviewed with his attorney all possible defenses, and by his plea of guilty, voluntarily waives those defenses and claims based upon his constitutional rights. Defendant understands that if we were to proceed to trial, he would have the right to an appeal, including but not limited to any issues decided by the court prior to defendant's guilty plea, including any rulings on the admissibility of evidence, the judgment, including the finding of guilt, and any issues regarding the guilty plea and the sentence. Further, defendant understands that if we're to proceed to trial, he'd have the right to file a motion under Idaho Criminal Rule 35, seeking a reduction of the sentence. The defendant's hereby knowingly, voluntarily, and intelligently waives all rights to appeal any and all issues in this case, and waives the right to file a motion pursuant to Idaho Criminal Rule 35. This entire agreement and understanding between the parties is so stipulated this 30th day of June 2025. But it's actually signed on July 2nd, 2025. Brian Kohlberger and Ashley Jennings. Just says plea agreement. It never says anything about rule anything, right? So we have to defer to the judge's words in court and assume that's the truth.
This is not a Rule 11 agreement.
Now, y'all know in the last week or so, we've covered the saga of the G's and the Laramies trying to get additional funds refunded from the Victims Crime Compensation Program. But for that to happen, defendant Brian Kohlberger would have to stipulate to the additional restitution, which, doesn't seem like it would be that big of a deal to add another $27,000 on top of $250,000 that you'll never pay. But it is in contention regardless with Kohlberger's attorneys. And now the state has filed a response to the objection by the defense. And you'll see in this request for sealing the state's exhibit, which I imagine the state's exhibit is going to be receipts provided by those family members. But this is the request for these exhibits to be sealed. Judge Hippler is signing on the order to stipulate to sealing those exhibits. And then here was the motion by the state to have those exhibits sealed. But then when I read the actual objection by the prosecution to the defense's claims that they shouldn't receive that additional money, I find something peculiar. Maybe you will as well. Now you can see, filed October 24th, 2025, Latah County Prosecutor's Office, Billy B. Thompson. State's response to defendant's objection to request for restitution. Comes now, the state of Idaho by and through the Latah County prosecuting attorney and respectfully responds to defendant's objection to state's request for additional restitution filed on October 7th, 2025. The state acknowledges the Rule 11 plea agreement filed herein.
This is not a Rule 11 agreement.
Regarding restitution under the Section 4 of the agreement, state may seek restitution orders regarding funeral expenses and crime victims' compensation reimbursement in an amount to be determined. At the time of the plea agreement, the state was under the impression certain expenses incurred by the victims' families would be covered by crime victims' compensation. Whoa. Let's back up just a second. The state acknowledges the Rule 11 plea agreement filed herein. So Thompson's referring to the plea agreement that was filed herein. He refers to it as a Rule 11 agreement. And he specifically refers to the restitution under Section 4 of the agreement. So let's not get confused about what he's talking about. Because when we go to Section 4 of the agreement that he's saying is a Rule 11 plea agreement, I believe I just read that to you. Remember? Plea agreement. Section 1, 2, 3, 4. The state may seek restitution orders regarding funeral expenses and crime victims' compensation reimbursement in an amount to be determined. So there's no confusing what agreement that he is referring to when he says it's a Rule 11 agreement.
This is not a Rule 11 agreement.
It was the plea agreement. The one we just heard Judge Hippler clearly state in court, this is not a Rule 11 plea agreement. So who's lying? Is it Hippler or is it Thompson in this? Let's see if maybe he just made a mistake and he won't bring up the Rule 11 part of this agreement again. Let's read the rest. Let's see. After the sentencing hearing, the state was informed that crime victims' compensation will not cover travel and lodging expenses for attendance of court proceedings. On behalf of the victims, the state submits the itemization of expenses that were incurred by the victims' families, including expenses not covered by the crime victim compensation, for the court's consideration. The state is affirmatively advocating for payment of funeral expenses as itemized by State's Exhibit 2 pursuant to the plea agreement. So what he's saying is they didn't realize that the travel expenses would not be refunded to the victims' families. So in lieu of them not getting that, they want to replace those with the funeral expenses that they incurred so that they can get those reimbursed on the back end. Defendant argues that the requested restitution should not qualify as direct economic loss since the victims' families receive third-party donations. Under Idaho Code and controlling precedent, directly injured victims may receive full restitution despite third-party payments unless those third parties qualify as statutory victims through contractual obligations to pay. Applying the Cheney analysis to this case, charitable donations such as those received through GoFundMe arise from voluntary generosity rather than legal obligations. Since charitable donors lack contractual obligations to pay victims, they can't qualify as statutory victims under Idaho Code. Therefore, their payments do not reduce the defendant's restitution obligation to directly injured victims. This is also supported by public policy, considering focusing on making the victims of crime whole for a defendant's criminal conduct rather than accounting for victims' good fortune and receiving community support. Lastly, defendant argues that the restitution should not be awarded based on defendant's ability to earn or pay money given his 4 consecutive life sentences plus 10 years. And defendant's objection provides clear authority for courts to order restitution from life sentence defendants. The statute mandates that courts shall order a defendant found guilty of any crime which results in economic loss to the victim to make the restitution to victims unless the court determines restitution be inappropriate or undesirable. The immediate inability to pay restitution shall not be in and of itself a reason to deny restitution. While Idaho law permits restitution orders for life sentence defendants, courts retain discretion to determine whether restitution is appropriate in individual cases. This discretion enables courts to consider the specific circumstances of life sentences, including the defendant's age, health, and realistic earning potential. In this case, there is a history of this defendant receiving financial compensation from family and third parties. By way of example, the state is attaching a summary of the financial contributions made to defendant while he was in custody at Ada County Jail and Latah County Jail. In the event the defendant is able to obtain financial compensation from third parties or family, the victim should have ready access to these assets for the satisfaction of their losses. In the event defendant is able to obtain financial compensation from third parties or family, so anything that they put on Kohberger's books, they're going to try to seize. Additionally, this case has and will continue to attract worldwide attention, which could result in the defendant prospectively receiving money subject to interception by the state treasurer pursuant to Idaho code. It's going to get even more worldwide attention since y'all lied all the way through it and we're now exposing you. Restitution orders may be recorded as civil judgments and should be collectible from any monies prospectively deposited in escrow with the state treasurer. So they're trying to mask the end of this as they're going after Kohberger's actual money that he's going to receive for restitution, ignoring the fact that he's already got almost over $300,000 that he already owes. This additional money has nothing to do with that. It all has to do with getting reimbursed from the Crime Victim Compensation Fund for money that they've already received 10 times over through public donations on GoFundMe. So all this gobbledygook for him to expose Judge Hippler's lie. Based on the above, the state hereby amends state's request for restitution filed on September 22nd, 2025, seeking outstanding funeral-related expenses per the Rule 11 agreement.
This is not a Rule 11 agreement.
And simply submits the balance of the victim's request for the court's consideration per the Rule 11 agreement.
This is not a Rule 11 agreement.
The state acknowledges the Rule 11 plea agreement filed herein.
This is not a Rule 11 agreement.
Under Section 4 of the Rule 11 plea agreement, the state seeks restitution from funeral expenses, crime victim compensation, reimbursement, in an amount to be determined. Plea agreement that we now know is a Rule 11 plea agreement. Just to verify, under Part 4, the state may seek restitution orders regarding funeral expenses, crime victims compensation reimbursement, in an amount to be determined.
Did I just lie out loud for the whole world to hear?
This is not a Rule 11 agreement.
Lo sé, you got some splaining to do. So, do those little fibs in court are those just little white lies that have no repercussions? Well, let me tell you, people that want to research this case now that wouldn't have been familiar with it back in the day as we were all going through this, they would get so messed up now just by looking at, like for instance, AI overviews. Yeah, you can Google, was the agreement in the Kohberger case a Rule 11 agreement? AI will tell you, no, it wasn't, and it'll tell you the reasons it wasn't and explain the differences. Well, we all know now that that is a lie. So let me ask you this. If Judge Hippler can stand up in court and say, this is not a Rule 11 agreement, which in reality means that he has the ability to impose a different sentence than was agreed upon by the defense and the prosecution if it's not a Rule 11. Yet, Bill Thompson just exposed Judge Hippler that he in fact did accept a Rule 11 agreement. He had no power to impose anything other than what was in that agreement because it was Rule 11. And he stood up in court and lied about what type of agreement it was. And you're expecting us to believe anything about any of the facts in this case that you present as facts when you can have your judge stand up in court and lie about what type of an agreement it was. You have got to be freaking kidding me. Good grief. I shouldn't have to pick fly shit out of black pepper and tell people to hold on to their hats and their shoes and their socks and expose everything in these videos when y'all expose yourself right in front of the world in court. And somebody besides old Pav better point this one out because it is egregious. Please like and subscribe to this channel though. Please post your comments, your thoughts, your criticisms. And until next time, Pavarotti's out.
Defendant, as part of the plea agreement, waives his right to appeal. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement.
Did I just lie out loud for the whole world to hear?
This is not a Rule 11 agreement.
Lo sé, you got some splaining to do.
You're a superhero.